want to discuss a specific aspect of an issue which is very often discussed in privacy conferences, which is convergence. But one of the results, convergence in privacy laws around the world, but one of the results of this convergence is the establishment around the world of new privacy regulators. And why is that interesting? Not only as a phenomenon, but these privacy regulators are probably the best placed to help us understanding what are the challenges, the opportunities in this area. And that's why we have chosen to focus on those practical experience in this panel. And without further ado, let me present briefly our prestigious panel. We have with us in a car, so we are moving fast, the Data Commissioner of Kenya, Immaculate. Your office was established in November 2020, and that was also when you were appointed. And we also have with us, doesn't seem so.
I'm there. We see her.
Miriam?
I'm there, Bruno.
Yeah, you are there, but Miriam is there, yes.
I'm here as well. Hello, good morning. Good
Miriam Wimmer, which is a director so member of the board at the Brazilian National Data Protection Authority, which was also established in 2020 and has since, through also for the Kenyan authority, been very active. And we are also joined here on stage by Tamar Kaldani. You are the former Data Protection Commissioner for Georgia. And you have also been the Vice Chair of the Consultative Committee of the Council of Europe Convention 108. We discussed this at length yesterday in another panel. And you are now, which I think makes your addition to this panel also particularly interesting, you are now advising a number of newly established authorities around the world, in particular in Africa and Asia. So I will start by asking some questions first to have a conversation with Immaculate and Miriam, who again thank to be with us today, especially Miriam, because it's very early in Brazil. What time is it? 5, 6?
It's not that early. It's 6:55 now.
6:55, okay. I hope. Okay, you're having your breakfast with us. Let's put it like this. I'll have first a conversation with Immaculate and Miriam, and I hope between the two of them, and then I will bring you in with your perspective and with your experience. Immaculate, how would you describe your office journey since its establishment? What examples of achievements and challenges would you like to share with us? You have to unmute.
Thank you, Bruno, for having me on this panel. You can hear me?
Yes.
Yes, and I have to apologize because we're in the middle of another conference. I'll have to step out as soon as I make my presentation. My panel starts in another 30 minutes or so. Having said that, thank you for, indeed, I want to confirm that there is a great convergence in terms of emerging data protection authorities across the globe. From our end, what do we see? Some of the things that we can say that can describe our office journey. When we started off I was appointed in 2020 November. We quickly had to set up a short-term operational plan, and so that you have short milestones, had what we call 100 days, so that it would tell us leaders show us exactly where we are going. We set up structure, of course, working closely. Then we established, and we worked, then in terms of structure, established a Ministry of ICT. So the concept of partnership and collaboration is one of the things that worked very well, because under the ministry, we were able to identify like-minded ministries to help us in some of the initial issues. Some of the initial issues were, of course, getting regulations. The then Cabinet Secretary gazetted a committee that helped us with the regulations. We were able to come up with a curriculum. We were able to come up with a strategy, of course, with partnership from development partners. We were able to, and we were also able to be guided by some of the donors, GIZ, who are very kind to give us consultants like Tamar, who is here today, to help us in terms of our work in the organization. So I would say, describing our journey since inception, collaboration, partnership, political goodwill, those are some of the things that have got us moving in the short term.
Very good. Thank you very much. And I would ask the same question to Miriam. The INPD, the Data Protection Brazil in Data Protection Authority in Brazil, has really done a remarkable job since its creation in terms of activities, guidance, presence on the regional and the international scene, and many other aspects. What are your main takeaways from these, I guess, busy but exciting years?
Busy and exciting indeed. So firstly, Bruno, thank you so much for inviting me to join this panel. It's lovely to be here with you and Tamar and Immaculate and sharing these experiences. And of course, I know you followed the process in Brazil very closely. We had almost a 10-year period of discussion until finally our law was enforced and the DPA was created. And I was also appointed in November 2020, just like Immaculate. So it's really interesting to see that we have faced some common challenges over this period. So I'd say that for a new DPA, the challenge is to simultaneously juggle the very operational aspects and the very strategic aspects, right? So on one hand, we were created from scratch. Of course, ideally, it would be perfect if we had a favorable political environment, strong support from the government, a culture of data protection in Brazil. But unfortunately, we don't work in an ideal scenario. We work with the real world scenario. And in this sense, it was, in fact, very challenging because the DPA was created with only 5 commissioners, no staff members, no offices, no computers, no one to answer the phone, no phones, in fact. So it was a really interesting period. And I'd say that over these past 2.5 years, our effort has been twofold. On one hand, actually creating a structure for the DPA to work and building up a team and staff members and the ability to actually enforce the legislation. And on the other hand, to actually approach the regulatory aspects of data protection, because our law is very similar to the GDPR, but it leaves a lot open to regulation. So I think, what I take away from this experience, firstly, the importance of strategic planning, of figuring out what the priorities are, what we have to tackle first, and then also coming up with a regulatory agenda. And this was actually an interesting exercise because we had just been appointed and we took our general data protection law and began listing all the topics that needed to be regulated. We came up with more than 50 items, also looking at what DPAs worldwide were doing. And it was very clear to us that we had to create priorities and figure out what we were going to do first, at the same time dealing with expectations from the public and from other governmental bodies who were very eager to see what we were going to come up with, and very anxious as well because this was a new law and there was quite a bit of panic. Also, I think what is super important from my perspective is to create the right culture right from the start in terms of how the DPA is going to work. And in our case, what we tried to focus on was very participative procedures for rulemaking, so public hearing, public consultations, meeting with experts, and also cooperation with other bodies. And this is something Immaculate mentioned. So in our case in Brazil, we have a quite complex institutional setup with many local consumer protection bodies, a large number of regulatory agencies, ministries. So creating cooperation mechanisms with these other pre-existing bodies was really important in order to allow us to be more effective and also to clarify who would be taking care of what, since the legislation, of course, is cross-cutting and interacts with many other laws. So I think one point, Bruno, that we learned, and this was also something that colleagues from Europe told us, is the importance of being selective to be effective. This is a phrase I heard during a class we had at Maastricht University, sponsored by the European Commission. And I think this is perhaps the most important lesson we took away over these 2.5 years.
Thank you. So I take from your 2 answers that indeed contacts, interaction, exchanges with stakeholders, with other bodies, with peers, also internationally, is very important from this phase. Having also a plan, being selective, as you just said, Miriam. We'll then ask the same question to both of you. Maybe this time, starting with you, Miriam, is there something you would do differently or that you think should have done earlier on in the process?
I was thinking about this question, Bruno, and of course it's easy to have hindsight, you know, what I would have done if conditions were different. I think considering the scenario we had, we did the best we could. But one issue that I do feel we might have tackled earlier is the issue of enforcement actions, because we chose to adopt a responsive approach, which was, I think, necessary at the beginning in terms of creating a culture and providing guidance and so on. But at the same time, the feeling I have personally is that enforcement is also a super important part of creating this culture of personal data protection and promoting compliance. So in our case, our law provided a grace period, an extended grace period for administrative sanctions. So we legally had to wait a while, and then we also took some time to regulate the procedure for applying administrative sanctions. And of course, I don't think sanctions are the only way to promote compliance. But if there is a feasible belief that sanctions may be applied, this might have sped up the process of creating the culture and promoting compliance with legislation.
Thank you very much. That's very interesting and sounds very familiar. Same question to you, Immaculate. Immaculate, could I just ask you to speak a bit louder because the sound is not ideal? And now you're again muted. No.
No? Now?
Yeah, yes, no, yes.
I will speak a little louder. I think, is that better?
Yes.
Yes, it's much better. Like Miriam has said, for me, I think one of the things I think we should have done much earlier is awareness creation. Because we went on to setting up structures, making sure we have a strategy, resource mobilization, but you can see the challenge of there's still a gap in as far as awareness creation is concerned to the general public. Of course, the issue of sanction for us has worked because initially a lot didn't provide for grace period, but we saw when we started giving sanction, there's a bit of a shake-up in the entire industry. So awareness creation, the other thing which I think we should have done earlier is in the law having licensed the licensed organizations that can help us in the compliance journey, because that way you're working towards improving the entire ecosystem, not just us. I think that because now we are seeing there's a bit of reluctance, and then also people have started running their own game in terms of compliance, and yet that will pose a challenge because then when you come and tell us, no, we have to license you, they will say, but you've not been there in the first place. I think for me, those are two things we probably should have done much earlier in this course.
Thank you very much. I think the two answers raise one of the challenges for any authority. All new is this finding that right, almost policy mix between guidance, awareness raising, enforcement, and how these three pieces, by the way, can complement each other. That's something certainly very, very interesting. Immaculate, I should have done this early on while presenting you, but I hope you're still there because I'm congratulating you. Yes, I want to congratulate you for being elected as the first vice chair of the network of African data protection authorities. I think that happened, if I remember well, last week, so it's very fresh. What do you see? I want now to move, although some of your answers were already leading there. What do you see as the main benefit, value of your office being member of such a regional network? And that question also, I can ask then the same question to Miriam, because in Latin America there's a very active Ibero-American network. So what is the main advantage for you, the main value? And do you see also a potential for networks? We see networks, more and more networks around the world. We have the EDPB here in Europe. The new chair was elected a few minutes, an hour ago. We see very happy, she's a former colleague, we see a very active network in Latin America. We see a very active network in the Asia-Pacific region. We see a very active network in Africa. So what is, especially for a newly established authority, why is that important? And I guess it is very important for you because you have decided also to play a leadership role in that context.
Thank you, Bruno, for the question, and congratulations to the new chair. And perhaps these are good tidings, Bruno. You might be just the next chair for the next network. Having said that, one, it's strategic. I think from a new data protection authority perspective, it puts on us a much more wider responsibility to then not only espouse principles and uphold the work around data protection, but also push it further into a regional level. This network will enable, and Kenya also has a regional hub, a tech regional hub. It's important then, as we push the world, to the African region in terms of data protection, it's also a responsibility for us as a country to make sure we are adhering to principles of data protection. Two, it becomes easier for us as a partner in being there to advocate for issues around harmonization of data protection laws. Three, we are in a position to advance the compliance for the ecosystem, because one of the challenges we have at the moment in our network is you find compliance will be an issue for many companies because we have different set of data protection regulations. So you see, I have, as being there as part of the leadership and seeing what challenges are there, is to push to having one voice. More importantly, is for us to speak in one voice, because we see divided house does not hold. It's important for us to push together, as we've seen strong networks like the European Data Protection Board, setting up standards for the region, which then cascade to the other institutions. So one, as Kenya being part of that, and we as Kenya being part of the leadership, that's one of the things we'll be pushing for, so that we have a standard across Africa to help us speak in the same voice. Certainly, there's an opportunity to collaborate and network with other data protection and regional data protection authority as one of ways of sharing experiences, like we see when we get together during the Global Privacy Network Assembly, sharing experiences, having a common voice, because you can't push the agenda on data protection on your own. It needs collectivity because we are addressing an ecosystem. Thank you.
Thank you. Miriam, your take on that?
I fully agree with Immaculate's comments. I think she raised great points. And I'd just like to comment that here in Brazil, we are a member of the Ibero-American Network of Data Protection Authorities. And I would also like to comment that even before ANPD was created, I think on our side, we were very anxious to be able to engage with our fellow DPAs. And I think also the other DPAs in the region were really anxious for Brazil to join and to sort of join forces and share experiences, because our region, in fact, has countries with many commonalities in terms of social, economic, political backgrounds. And it certainly makes sense for us to cooperate from a regional standpoint, besides the other fora we have for cooperation with other regional blocs or with in international groups such as the Global Privacy Assembly and so on. So I think for us, some of the great advantages are related to the possibility of sharing experiences between DPAs that sometimes face common realities and common difficulties. And also something new we are beginning to experiment is the idea of joint enforcement actions.
Yes.
So this, I think, is lovely in the books, but not so easy on the ground. But we have, in fact, begun discussing some points that, DPAs in the region are facing, and the idea that even if we are not formally having joint investigative procedures, we can simultaneously address some issues that are common to the region and share our experiences with these issues in order to make our actions also more effective. And I think, just generally speaking, Bruno, if we have over 130 countries in the world with data protection laws and data protection authorities, discussing these topics in terms of regional blocks just makes common sense, because we cannot have 130 bilateral conversations for each country in the world.
Yes, absolutely. And this is also very much at the heart of our agenda here, meaning in a few weeks, we will propose in Europe a new legal text to facilitate cross-border cooperation, because that's absolutely essential when authorities are very often dealing with the same practices, if not dealing and addressing practices put in place by the same companies in various jurisdictions, and it has also other advantage in terms of, for instance, of creating. It's not only about enforcement; it's also creating more legal security in making sure that similar concepts are interpreted, more legal certainty, similar concepts are interpreted in a harmonious, in a consistent way. Staying in Brazil, so the growth or the development of your authority, Miriam, is interesting because it was like a two-step. In 2022, you became a more fully independent body. We thought now we don't have time, and I think Immaculate also has to leave soon. I still have a question for her, but was this just a legalistic or formalistic change, or did it have an impact? And if so, what was that impact?
No, it was not just formalistic or legalistic. I feel that it certainly had an impact. And in fact, if you look at the whole process of approval of a general data protection law and creation of the DPA, these concerns about independence were always present. So ANPD was created firstly as a body connected to the presidency of the Republic, so within the central executive branch. But our law foresaw that within a 2-year period, this legal nature should be reassessed. And in fact, last year we had a provisional measure, which has the force of law, that changed our legal nature to a special autarky, which is something like a regulatory agency here in Brazil. So we are currently connected to the Ministry of Justice, but this does not imply any sort of hierarchy between the bodies. It's just a formal connection, and we have full independence, autonomous decision-making powers. Our decisions cannot be reviewed by any body within government, but only by the judicial branch, of course. And we also have a number of other guarantees, such as a separate budget, for instance, and the ability to request civil servants from other bodies to work at the ANPD. So I think there were legal effects, but also symbolic effects. And this is super important because at ANPD, we are responsible for supervising not only the private sector, but also the public sector. So it's crucial for us to be free from any sort of pressures that could be exerted to prevent us from actually carrying out our duties, especially if we look at the public sector. So it wouldn't make sense for someone to cut off our budget if we start investigating them. This is something that should definitely not be possible. And now it's not possible. And also the feeling I have, this is quite subjective, is that somehow we have stepped up. You know, we are in a different position to deal with our colleagues in government, to deal with private companies, also to relate to DPAs worldwide and to other organizations, because as a fully independent body, we are in fact entitled to state our technical opinions and to defend them. And I think this is absolutely crucial when we think of protecting a fundamental right to data protection, as we have in Brazil formally enshrined in our constitution.
Thank you. Indeed, a very important development, and I think also I have a vested interest almost in that, because I'm thinking also about our adequacy negotiation and how how that development is crucial also in that respect. Immaculate, I know you have to leave, you have to go to another event, but looking ahead, what are your main priorities? Maybe both at national level and now that you have also regional responsibilities. Is it to echo what you said before, very much still awareness raising? Is it something different? You know, Kenya is, in terms of processing of data, of data economy, is a particularly important center, in particular with an important fintech sector. Is that very much on your agenda, or are there aspects you haven't yet mentioned that you would like to share with us?
Thank you, Bruno. Looking ahead in terms of the days to come, as an office, of course, awareness creation remains one of our top priorities, because I believe that when the data subjects are aware about their personal rights as data subject, they're able to push back and make demands on the duty bearers, in this case, data controllers and data processors. So that remains both a country agenda and a regional agenda that we need to do much more than is required. Of course, looking ahead also, we are seeing continuously emerging technology on AI and big data, and they present both challenges and opportunities. And I think the challenge for us as a data protection authority is to be ahead of time. And even if we, at times, you're stretched in terms of, you may not be able to respond as quickly as possible, but to be in those conversations. And of course, even that affects us at a regional level, to be able to look at how then we're in those conversations around AI and how it is affecting our work. 3, the issue around data portability remains something that we have. When we look at data portability, it's a big conversation in the continent, and also just combining that with the cross-border data transfer. I think as a continent, it's time to actually do some introspective in terms of how we can make that much more easier so that we're able to facilitate trade, because Africa remains one of the largest trading bloc, but totally unexploited. And therefore, if we allow free trade to even make the opportunity for doing business in Africa even higher, even better. And those are issues that also affect us at a country level. In terms of guidance notes, I think it remains an issue for us. This year, we want to just release around 4 of them on fintechs, because that fintech remains one of the biggest challenges, not just us, also within the continent, with MNOs, that is that is a telecom regulator, the telecom with security, that remains also top of priority. It's unique to NADPA, the Network for African Data Protection. I think one of their challenges is resourcing, and that is top of our agenda, that we should be able to resource that organization so that they're able to do much more. And also the presence, making sure at whatever minimal budget we have a lot of presence online, and we're able to reach out to many people as possible. And then, of course, bringing on board, as you know, over 33 countries in Africa have some sort of data protection regulatory framework, but in NADPA we are shy of 20. So I think one of our responsibility as a team is to make sure we are onboarding as many data protection authorities as possible to this network, where we'll be able to share more and more in terms of what we are doing, and also pushing the agenda of data protection. In the long run, the objective is to improve the rights of data subjects, protect them, but also make sure that we are making the ecosystem much safer, and making people who do deal with data protection are much more conscious and sensitive to the data subject. Bruno, you'll allow me after this to step out?
Yes.
Yes,
Thank you very much. It was great to be in a car in Nairobi, but thank you very much, Immaculate, and have a good rest of the day, and a good conference, and see you very soon.
See you soon.
Thank you. And Miriam, does what Immaculate just mentioned, does it sound familiar to you, or are you thinking in other directions in terms of priorities? Again, looking ahead.
It does seem familiar, and I'd say, at the basis of our challenges, sort of being able to balance and understand these different dimensions of data protection, realizing that on the one hand, we are talking about something that is an economic asset in terms, has an economic impact, and on the other hand, we are protecting fundamental rights. So she was speaking about the importance of international data transfers for international trade, for instance, and this is, of course, true. This is a huge issue also here in Brazil, but at the same time, we are speaking about maintaining an appropriate level of protection for data, even if it is not located in our country. So I think this is, I think, an example of how it's important to balance these different needs. And when I look at our regulatory agenda and our challenges moving forward, I think I'd like to highlight that we are simultaneously facing issues that are very basic and also issues that are super complex. So here in Brazil, when the law came into force, there was initially a huge discussion, a huge misunderstanding about very basic concepts, such as who is the controller, who is the processor, what should the DPO be doing, what does this legal basis mean, what is legitimate interest, issues that have already been covered in other jurisdictions, but here in Brazil raised huge questions. So I think that when we look at the challenges lying ahead, we simultaneously have to deal with these very basic building blocks, for instance, data subject rights, data breach notification, clarifying the legal basis for data processing, but also complex and challenging issues such as defining what is high risk and large scale data protection, anonymization, pseudonymization, data sharing in the public sector, which I think is an issue here in Brazil that has been very controversial, and we have a number of Supreme Court decisions on this issue. And also matters raised by new technologies. And she was speaking about AI. Here in Brazil, we also have an AI bill going through Congress. We also have discussions on new legislation on platform regulation, on misinformation. And I think one of our challenges also is looking forward, making sure that these new proposed pieces of legislation are harmonious with what we already have in terms of guarantees related to data protection. So make sure the concepts are aligned, also making sure that our institutional setup is coherent, because there is a trend, I think, that every time you have a new issue, you need to create a new authority. And this, of course, may create imbalances or may create an overlap of responsibilities. So I believe this is also something that is being discussed in Europe, but here in Brazil, it's certainly very much the case. We have discussions on legislation that is quite similar to Digital Services Act or Digital Markets Act, AI Act. And I think, putting these pieces of the jigsaw puzzle together in a coherent and systematic issue is perhaps one of our main concerns in terms of not weakening the protections we already have for data subjects.
Absolutely. What you just said sounds to me terribly familiar, and actually was at the center of many panels of this conference, and I think will be our main source of work in the coming years, making that jigsaw work, both in terms of substantive rules and governance model. We'll come back to you, Miriam, but now maybe it's time to go to Tamar. Tamar, you have heard what Miriam and Immaculate explain, based on your experience working closely with different DPAs around the world. Do you see some common trends in terms of opportunity and challenges? I think we already heard some. And do you see them differently now compared to when you were the head of a data protection authority in Georgia, as we recalled before?
Thank you, Bruno. Yes, indeed, I've been in the shoes of newly appointed commissioners, and I know and remember how challenging and at the same time rewarding is to build the office from scratch, and how important is any support you are getting throughout this journey. And that's why I really appreciate this opportunity that I have with European Commission and its project on digital international cooperation to really help authorities on operationalization, making first steps towards enforcement, investigations, like helping in strategy development. And yes, there are common challenges that we all faced, including a lack of financial, human, and technical resources, or the huge implementation gap that we see between the new data protection legal frameworks and the reality on the ground. And that's why the capacity building, cooperation, and engagement with more experienced authorities that can share not only best practices, but lessons learned is so important. And both authorities I had the chance to benefit from Data Protection Academy, and I believe we can further explore benefits that it brought. In addition, I had a privilege to work with a number of other commissioners, and looking even to this panel, I think we have to be all very proud and appreciate the new cohort of privacy leaders, with the right vision that will bring the international cooperation, the joint actions for convergence to the next level. This is really indeed a great opportunity and strength to this network. And then, yes, to your question about whether I see it differently, yes and no, because obviously there are some common challenges that I already described, but at the same time, nowadays, compared to what was happening in 10 days, there are also more opportunities. First of all, data subjects, individuals, as well as data controllers and processors are much more aware of why privacy and data protection is important. They're much more aware, I would say, about their rights as well as obligations. Secondly, nowadays, data protection authorities have more opportunities and channels to engage and reach out to different sectors to bring this understanding and awareness. There is a understanding that international and regional cooperation is very important, and how, as Miriam said, authorities can help each other to address the common challenges by joint actions, including enforcement actions. And last but not least, now more support is available through European Commission, its project, through other developing partners, including like GIZ, Council of Europe, and others. And I think this is very important, really, to help authorities to make bold and active and fast steps towards enforcement, towards building compliance. And then what I also have noticed that authorities nowadays, along with their important powers, investigation and enforcement and providing guidelines, they are much more now advocating and promoting how building, let's say, privacy-friendly systems and products can help to gain competitive advantage. And I think this is a very strong point to further explore, to convince businesses and public institutions how privacy can help to build the trust among customers, among citizens, get competitive advantage. And this is the conversation I observe at the national and regional level, and this is something we have to explore further. Thank you.
Thank you. We'll also give a chance to the audience to ask questions. But Tamar, just staying with you a second, you've mentioned the Data Protection Academy, which this is a project we have created as the EU, which is there as a platform to allow the exchange of information, knowledge, best practices between EU regulators and foreign regulators. And we have worked, including with the two regulators that are represented today. But in terms of, and you are very much involved in that work, and I want to thank you for that. What are some of the needs in terms of capacity building you had to address, or you were asked to address? And again, are there differences? Because what I've heard today is, and it reassures me actually, and it confirms what we are also seeing in Europe, but there's a lot of commonalities. Can you say a bit more there on your experience on the ground?
Yes, absolutely, and with great pleasure. Miriam probably will contribute further. What I think, why the Academy is really as a flagship initiative of the Commission and project, why it's so important, because it is always tailored from the experience that I have. It's always tailored to the needs of particular DPAs. Yes, there are common issues like how to translate those concepts from theory to practice, but then we always, and this is the practice that we have established, prior to delivery the program, we developed the training need assessment, which is based on the staff profiles and needs of particular authorities, and in addition to brilliant academics and experts who contribute. What is most important, the Academy allows to have direct exchanges with European data protection authorities who share all the nitty-gritties related to, for example, providing guidelines, awareness-raising strategies, investigations, enforcement actions. We also address issues like how DPAs can effectively regulate transporter data flows, or how they can regulate emerging technologies that were just discussed as a common, let's say, issue. And I believe that this academy is really different from other capacity building activities that data protection authorities could benefit, because at the same time, like, it helps to build this cooperation. And just to give you the Kenyan example, the academy was followed by the study visits to Europe that was organized by Council of Europe and the GIZ, and it was a very neutral continuation of this conversation, the direct links and engagements with French or German authorities, meeting with the EDPB, discussing like how they could cooperate, what could be shared, and how through this cooperation, authorities by joining forces and networks by joining forces can address those common challenges. So this would be my takeaway.
I must say that this is for us very important. The secondment exchange of personnel in both directions, having this possibility that indeed foreign regulators can send staff members to really work with our data protection authorities, being sort of embedded, if you want, in investigation teams. And we are looking also, of course, to do that also in the other direction, because I think that indeed matters. First of all, for those human contacts, but also, again, to exchange information, knowledge, best practices in the most tangible way. Miriam, any reaction to what Tamar has been saying on your side, or any other points you want to raise before we ask the audience whether anybody wants to ask a question?
Yes, I'd like to comment specifically on the Data Protection Academy, because in fact, here in Brazil, this was a really important contribution to the development of our DPA. So when ANPD was created in 2020, we didn't have a huge pool of data protection experts within public administration that we could just, pick and bring to work with us. In fact, even within government, we didn't have that many experts. We had a handful of people who had followed the discussion process that led to the approval of the General Data Protection Law. But people were, in fact, at the very early stages of understanding these new concepts and what sort of approach would make more sense. So I think it was in June or July 2021, or perhaps a bit earlier, where we had the opportunity of participating in the Data Protection Academy. And I think we had at that point around 20 staff members, something like that. And almost all of them participated, from the board of directors to the people who were, beginning to work with administrative procedures. And I think at that point in time, where we were still getting started, this mix of a theoretical approach and a hands-on approach was very important, because on one hand, we were able to build our own interpretations of the law in a manner that is consistent with what other jurisdictions are doing. Of course, we're not speaking about laws that are identical, but that have many commonalities. And on the other hand, also realizing what the technical challenges are, the practical challenges on the ground of a DPA. And one point I'd like to highlight also is that this course was very interesting. It was very much tailor-made for us at that point in time, but also looking at our reality today, also our needs have changed somewhat. So if I were to design this class today for our DPA that is now 2.5 years old, I think we have moved forward a lot in terms of clarifying concepts and interpreting the law. And what we perhaps would need now is even more practical advice on how to carry out enforcement actions, how to deal with, the concrete aspect, the operational aspects of data protection. And in this sense, the network of cooperation that we were able to build from participating in the course and then afterwards, of course, from engaging in international discussions has been super helpful for us to be more effective and more, I think more to make less mistakes in terms of addressing these different challenges.
Thank you very much. And of course, whenever you want, we can do the second one, which will address this, of course, evolving needs on both sides, because this is a mutual beneficial experience. Any questions from the audience? Yes, there's one there. So I think you have to use one of the mics.
I'm Stuart Dresner from Privacy Laws and Business, and I was reflecting about regional groups, and I know the most successful ones are perhaps some of the oldest, the Nordic groups, and they meet quite frequently, once or twice a year, whereas the Eastern European group is not so lively. It was organized by Poland and was going quite active for a while, but if you looked at the website, there's nothing sort of keeping it fresh. Whereas there's the possibility for new ones, like maybe a Mediterranean group, which has not yet happened, but is potential, and also the potential for a Caribbean group. And in fact, we at Privacy Laws and Business are organizing the opening session at the GPA in Bermuda on this as maybe as potential for growth. So I'd suggest and ask you if you agree that the potential for keeping these regional groups active are to meet at least once or twice a year, as APA do, huge geographical area, but they meet once or twice a year in Asia Pacific, and keep a website active. So that are my questions. Do you agree that they're the important elements to keep regional groups active?
They're certainly important, and I think the conversation we had today, that will of course leave Tamar and Miriam answer to that, but I don't think we need more groups. I think we need groups that are equipped, that do not just meet, but have the powers to bring that level of cooperation to what is needed in this area. I'm always surprised how much there is enforcement cooperation in areas such as competition or financial supervision or consumer protection, and how little there is in the area of privacy in terms of, and cooperating is not meeting in a nice place, is, as Miriam was saying, on a certain investigation, being able between regulators to exchange information on that investigation, compare notes on the approach, on the legal analysis, develop common guidance. And here I think we see that networks, we call them groups, networks, have become really powerful actors on the privacy scene. There is, of course, the European Data Protection Board here in Europe, but the Ibero-American network has developed, which I think is extremely important, compliance tools, such as, for instance, model clauses for transfers. That's, again, it brings cooperation to the next level, and to a level which is important not only for the data protection authorities that join those and that participate in those networks, but also for stakeholders, which are then provided with tools to facilitate compliance. And the same, I think, is true in many other regions. So yes, I see a lot of potential for this cooperation at regional level. And what is missing now is, as Miriam was very well saying, is that now that we have structured networks, that they cooperate amongst each other, so that we have this network effect at global level and this critical mass. But I don't know if the question was addressed to me, so, but I'm maybe not used to be a moderator. I should have limited myself to be a moderator. And Miriam, do you want to, because I was actually very much speaking and basing myself on things you had said.
I fully agree. And I think that perhaps a point to add, because the question was also in terms of meeting once or twice a year, and that my experience working in government for over 16 years now is that cooperation depends not only on formal mechanisms, but also on building relationships of trust between different organizations and between individuals. So I do agree that, having regular meetings and people actually getting to know each other face to face is important for cooperation to be effective, because when you have an emergency, you need to be able to pick up the phone and call someone and say, listen, what are you doing with regard to this issue? How can we work on this together? So there has to be a good mix of formal and informal mechanisms in order for cooperation to be effective in my own experience.
Thank you. Tamar?
I fully agree. Indeed, efficiency should be increased. Visibility probably should be increased as well. And the more practical tools for networking and cooperating, especially in enforcement, as Miriam said, it's very important to have the contact list, the people you can call to get the information. And I know for sure that in many networks that now there is a rethinking process, like how to increase efficiency, how to increase visibility, and how to get reach concrete outcomes and results, which will be more tangible. Although this case handling, for example, workshops or enforcement cooperation workshop, they're also very useful for the capacity building of the authorities. I had a chance to be part of, let's say, represent my authority in many networks, and I agree with the proposed, let's say, suggestion, and I fully agree what our panelists and moderator especially said. Thank you.
Thank you, and thank you for this excellent question. I see a second, very good, that has, thanks, Stewart. You see, you opened the way. You broke the ice.
Thanks a lot, Sebastian from Kaldani International. I'm curious to ask Miriam how GDPR inspired Brazil to adopt its national data protection legislation. And of course, if you could share with us some more details on the adequacy discussions that you are engaged with Bruno, with the Commission, anything like on the timeline potentially on, or Bruno, if you could share with us some ideas on what the adequacy discussions are touching on, which are the main points on that. Thanks a lot.
Miriam.
I was going to ask if you wanted to take this one, Bruno. But of course,
you're not engaging with Bruno. She's engaging with the European Commission. It's a slight nuance.
Okay. So thank you very much for the question, Sebastian. In fact, if you look at the LGPD, our General Data Protection Law, and the GDPR, it will seem very, very, very familiar, because we, of course, have a common approach in terms of an ex-ante data protection law, where you need to have a legal basis in order to process personal data. You have a number of data subject rights. You have a certain number of responsibilities also to apply to controllers and processors. So in general, it is a very similar approach. And also in specific articles, you will see wording that is, I'd say, almost identical to what you have in the GDPR. There are some important differences. So for instance, under the GDPR, you have 6 legal grounds for processing personal data. In Brazil, you have 10. So there are also differences in terms of international data transfers, minor differences, nuances that have to be well understood. But I'd say definitely the European approach has strongly influenced legislation here in Brazil, not only regarding personal data, but also regarding other initiatives aimed at regulating the digital environment. And as to adequacy discussions, I'd like to say that, of course, since we have such a similar approach, it certainly makes a lot of sense for us to engage with the European Commission and to move forward in discussions seeking adequacy recognition. These discussions are going on, I'd say, informally at this stage. So we have a great proximity with DG Just and with Bruno and with other team members. And I think there is a common interest, I'd like to say, on both sides in order to advance these discussions and move forward in a more concrete manner, while recognizing that also Brazil is currently regulating international data transfers. So there is some ground to be covered. But I'd like to hear Bruno also.
No, I can confirm, and I can confirm that proximity. I think actually adequacy and is a quite low-hanging fruit, because we have, as Miriam has said, not only similar data protection frameworks, but we have similar legal landscapes. Brazil is a country where privacy data protection is a fundamental right, for instance, and that has all sorts of consequences also when we think about governance access and what it means to governance access to data. So yes, those are indeed a process that have to follow their process, but we are very excited, I would say, by that perspective. Yes, please.
Okay. My name is Tevin Gitonga, and I work on data governance matters, particularly data protection in Kenya with GIZ, and part of a project that's together with GIZ under the BMZ and Team Europe under the European Commission on data protection. And
maybe you just want to say, because we are all in Brussels and we all use acronyms,
okay,
what GIZ is.
Okay, GIZ is a German Development Corporation, and we have a project on data protection. It's part of a Team Europe initiative. So we work a lot with Tamar and the European Commission on some of the work in Kenya that Immaculate alluded to. And the question I have is, maybe from some of our observations in Kenya, has been an interesting multi-stakeholder approach when it comes to the building of a data protection culture, where we quickly realized it's not only the commissioner's job, but also we started seeing civil society coming in, and interestingly, even private sector, because it became more of a economic value to them. We started seeing, for example, some digital lending platforms talking about, we are data protection compliant, so use our products. So I'm curious to hear what the situation has been in Brazil. Are we seeing a rise on the other players also coming in, particularly civil society in enabling data subject awareness, or private sector trying to kind of self-regulate and also take steps as well? So rather than just the commissioner being alone, but more of a kind of building of a community.
Miriam, you want to?
I think it's a great question, Kevin, and I am familiar with GIZ, that they're also active here in the region. I think the answer is yes to both of your questions. So the first point is that we have, in fact, a very active civil society in the field of digital rights here in Brazil. And they have, had strategic litigation cases brought before the Supreme Court in order to advance the recognition of a fundamental right towards data protection. And these groups are also very active when we have public consultations, public hearings, and also before Congress in lobbying and pushing for the changes in legislation that they think are relevant. So I'd say definitely yes for civil society work in terms of promoting this data protection culture and asking the right questions when necessary. And at the same time also, since our law does provide for mechanisms of self and co-regulation, we have also seen interest from certain private sector groups in terms of bringing up codes of best practices, codes of conduct. They are not formally recognized by the DPA, but we do see this as a good practice, as something that is, to be supported under the general principle of accountability, that organizations should, make their own risk assessments and take the necessary measures in order to be compliant with legislation. So definitely yes. I think that when we look at regulation in a broad sense today, this is to be understood not only as regulation made by the state in the strict sense, but also by these different movements, by private sector groups, civil society, that end up creating a positive environment for data protection.
Okay, we are coming to the end. One last question, but you are one of the organizers.
Indeed. Thank you for the opportunity to ask my question. Aaron Martin with the International Digital Cooperation Project. Yesterday we heard a fascinating panel about the development of a toolkit to facilitate the use of model clauses between ASEAN and the EU. And I think that's a really good example of this sort of cross-regional cooperation on sort of practical tools and the development of tools to facilitate transfers in a secure way. And also we've heard a lot about the Data Protection Academy, which I think is another interesting sort of platform for exchanges between regions. But if each of you had to choose a topic for DPAs of sort of LATAM, Africa, and the EU to work on, what would that topic be, right? So if you could sort of choose your favorite issue for increased cooperation and collaboration between the networks, what would you choose? And Bruno, you can take off your moderator hat and provide your opinion on this. And I will say, and I just want to observe that the Latin American network, the Ibero-American network rather, recently took this coordinated action against OpenAI and ChatGPT, which I think is very interesting and a really good example of cooperation at the regional level. And I'm wondering if that sort of thing is where we're headed in terms of the inter-regional network. Thank you.
Thank you, Aaron. Tamar.
Thank you, Aaron. Actually, I cannot speak on behalf of the Kenyan Authority or African network of the DPAs, but based on the discussions that I observe, I think that indeed, if you look in Africa, there are so many companies that do business across the whole Africa or in East or West, and then you see a great need really establishing some, let's say at the regional level, some basic standards, commonly acceptable standards that would drive this the data, let's say, exchange with trust and data transfer with trust. If you look more globally, I was looking recently to update that Professor Gencarelli published, and it seems that for 2023 we have 162 laws, data protection laws. There are 70 more bills available. In Africa, like 36 states have already data protection laws, and this is a huge effect and huge step ahead, because if you will compare, this is really Brussels effect, I would say, as well as the need taking into account the very high speed of digitalization, digital transformation. So this gives another boost to agree on commonly acceptable principles that could be reflected in model contractual clauses and other let's say, data sharing exchange tools for the region.
Miriam?
I do agree with Tamar. Thank you, Aaron, for the question. Firstly, I think it's unfair to say we have to pick one topic. I think there are so many topics to be explored. But if I had to pick one, I do think that the issue of cross-border data transfers is something that is in the common interest of countries within a region and also between regions. And I'd say that here, looking at Latin America, we have a very interesting situation because we have different, I'd say, influences. So we have some countries that have a European adequacy decision. We have countries in the OECD. We have countries that have signed Convention 108. And of course, the regional network also has worked on model contractual clauses. So I think harmonizing these different approaches and figuring out what works for us as a region is perhaps an important step for us also to be able to discuss with other regions, as is the case of the toolkit you mentioned, to facilitate transfers between Asia and the European Union. So I would agree that this is perhaps one of the topics that is most promising in terms of cooperation.
Yes, I would agree. And again, this shows, to come to a common theme, that the future is really in this cooperation amongst networks, that by facilitating cooperation at regional level, you also facilitate cooperation at global level, and this has an impact. We can see it, including on the development of compatible transfer mechanisms. So I don't see any other question. I just want to thank you all. First, thank the audience, but even more importantly, the panelists, because you gave Miriam, and Immaculate has left, but we'll pretend she's here, great insight in what meaning your reality, what's happening in Brazil and Kenya, but also in what brings us together. And of course, Tamar, we were very privileged to have you very much confirming what we have identified as common challenges, but as often challenges are also opportunities. So thank you very much, and see you all soon, virtually or not, I hope. And Miriam, we will certainly meet soon. Thank you. Bye-bye. Have a good day, Miriam. And thanks again for being with us so early.
Thank you so much for the conversation. Have a nice day.
Thanks for excellent moderation of this panel and also supporting me as a panelist.